$1 billion fraud. Court refuses detained CBEX operators bail. The Federal High Court in Abuja on Monday refused to grant bail to 3 detained promoters of crypto bridge exchange, accused of involvement in a fraud exceeding $1 billion. In his ruling, Justice Emeka Nwite held that, based on the affidavit evidence presented by both parties, the case against the defendants appeared strong. The judge, on April 24th, had previously granted the application of the EFCC to arrest and detain 6 CBEX operators in connection with the alleged fraud. The order followed an ex parte motion filed by the EFCC's counsel, Yusuf, which sought detention pending the conclusion of investigations and possible prosecution. The 6 defendants include Adefowora, Abiodun, Adefowora, Oluwanisola, Emmanuel, Seyi, Oloyede, Avwerosuo, Otorudo, and Chukwuebuka, Ehirim. In the motion ex parte, filed on April 23rd, the EFCC outlined 4 grounds for its application, including its statutory duty to prevent and detect financial crimes through investigation. Yusuf argued that some defendants were at large, necessitating a warrant of arrest to enable proper investigation and prosecution. According to the EFCC, the defendants, through their company St Technologies International Limited, promoted CBEX by advertising investment opportunities and luring members of the public to invest cryptocurrencies on the CBEX platform. The agency alleged that the defendants promised unrealistic returns of up to 100%, requiring victims to convert their digital assets into stablecoin USDT and deposit them into the suspects' crypto wallets. Initially, victims had full access to monitor their investments. However, once deposits surpassed $1 billion, the CBEX platform became inaccessible and withdrawals were blocked. Investigations revealed that the scheme was fraudulent and that St Technologies International Limited, although registered with the Corporate Affairs Commission, was not authorized by the Securities and Exchange Commission to offer investment services. The EFCC further disclosed that the defendants had vacated their last known addresses in Lagos and Ogun states. A warrant of arrest was thus necessary to trace and apprehend them. During a hearing on the 11th of June, counsel for the defendants, Abiodun and Justice Otorudo, argued for bail, citing Section 35(1) and Section 36 of the 1999 Constitution, as amended, and sections of the Administration of Criminal Justice Act, 2015. They sought to vary the court's earlier order permitting the EFCC to detain their clients, requesting bail pending the conclusion of investigations, arraignment, and trial. However, the EFCC opposed the bail application, arguing that the defendants were implicated in a fraud exceeding the budgets of several Nigerian states combined. The Commission also noted that new petitions from victims continued to emerge. In delivering his ruling, Justice Nwite acknowledged that a formal charge had been filed against the defendants and was awaiting assignment to a court. He rejected claims that the first defendant, Abiodun, required urgent medical attention, stating that the EFCC could provide necessary healthcare. In view of the foregoing, and considering the nature of the case, as well as the fact that a formal charge has been filed, I hold that the interest of justice will be best served by transferring this application to the court where the charge is pending for simultaneous arraignment and hearing of the bail application, the judge declared. The application was subsequently refused.